So, welcome everyone to the consultation. We normally start promptly at noon on Fridays. However, Mr. Floyd is struggling for some reason today. So we always ask everyone to please check us out on all of our social media platforms. We have TikTok, we have Facebook, we have Instagram. What else do we have? Twitter, LinkedIn, all of those platforms, basically any social platform that there is. Keon has us now on everything. So thank you, Keon, for doing such a great job. So at the onset, and my apologies because I am getting over something today, so I'm a little bit stuffy. But at the onset of each event that we do, we always state in the beginning, middle, and end that please do not take this as legal advice. These discussions are meant to kind of just be roundtable discussions where we talk through different fact patterns and we kind of give our opinions as to what may or may not happen in certain situations. But obviously, every case and every fact pattern is going to be different. And what you'll notice throughout the I guess conversations that we have is that often one little thing can potentially change the trajectory of the entire case and what our opinion will in fact be. And so it's very important that if you ever find yourself in a situation like this, that you get you a good attorney, you consult with that attorney, you tell them your particular situation, and you rely on their opinion and their advice, and you do what they tell you to do, because this is not legal advice. This is merely two attorneys talking through some fact patterns. So
yeah, I'll ask you the first question. You don't need to respond. All right. So if I do a character letter for someone, does the other party parent get to know who wrote that letter? Do they tell the other party about what the letter states? We get it a lot though, right? Can I just present a character letter? So I think maybe we just touch on that real quick and then we'll move on. So character letters generally not admissible in court, never admissible in court that I can think of. So I get a lot of clients that will say, I've got this character letter from so-and-so, or I can get so-and-so to write me a letter. Doesn't matter. They need to appear in court to testify. I can't think of a situation where we've been able to get those in as evidence.
I mean, what if the person's dead? Would that be a potential hearsay exception?
Unavailable witness. I don't know that a letter. I don't know. I've never been able to do it.
Yeah, I haven't either. I always say the person has to appear, they have to testify, or else it doesn't come into evidence, period. So.
All right. So next question. If I leave my money to a grown child from my life insurance after I pass, and this adult child owes back child support, can that money be taken away and given to those kids of what's owed?
I'm going to go ahead and go out on a limb and say, yeah. If he's eligible to receive money from a life insurance policy, then yes, the Office of the Attorney General can put a lien on those funds. And the only reason that I say that is I have had a client in the past where he owed back child support, and the AG actually he owed back child support, and the AG put a lien on a check that he had received from his insurance company for his vehicle in order to recover those funds. And so I would presume that if they could put a lien on those funds for car insurance, and they likely can do the same thing for a life insurance policy. I've never personally seen it, but the logic is there for me. The other thing that I've seen happen in the past is I actually, it was just a consultation that I did, but I had a gentleman who had been wrongfully imprisoned for several years. And when that happens, and when they I guess make this finding that you're exonerated and you shouldn't have been put away for all these years, the state or the government will give people a check. It's not very much. I think it was like $10,000 or $15,000 a year. But he was in jail for several years, and so he had like an $80,000 or $90,000 check that was coming to him, and the AG actually put a lien on that money and kept most of that money for back child support. And so I'm going to go ahead and say yes, that can happen. And so you probably want to figure out a workaround.
So, but could they do it? They could attach the lien before the person died, right?
No.
So
But when,
they'd have to intervene into the probate suit, or like, how would they even know if he was going to get that money?
so I don't know on that other case how the AG knew about the lien, because basically he got into a car accident and there was damages to the vehicle, and I want to say that there was some that was for some personal injury too. And I don't think that they put a lien on the personal injury claim, but the damage to the vehicle to replace that, the AG found out about it somehow, and they put a lien on it. So, yeah,
It knows everything.
they know everything. They know all. Scary. So I would say maybe set up some sort of a trust, and make sure that this trust account, your son doesn't have the ability to go in and take all of the funds, because I think that may potentially also be an issue. But if it's a slow payout over the course of several years, maybe that's a potential workaround. I'm not a probate or trust estate attorney or anything like that, but perhaps that might be something that you want to look into to see if you can avoid that potential lien. Or you could just tell your son to maybe just pay child support. I don't know. I'm gonna go out on a limb there and just say maybe we just do what we're supposed to do. So next question, Mr. Floyd. Why isn't there a trial by jury with child support?
The reason that the jury can't hear child support cases is because the law says a jury can't hear child support cases. But I think the theory behind that is child support is a question of law, not a question of fact. And so judges determine questions of law, juries determine questions of fact. And so the family code is clear on how to calculate support. I think there's some exceptions actually where juries can hear child support. Like I think for adult children, I think they can hear issues like that. Not 100%, but I think so. But generally speaking, they can't hear child support because I think it's a question of law. Well, primarily because the law says they can't, and that's what the legislature's put in the code. But I think it's because it's a question of law. So that's why they can't hear child support. But the income is kind of a question of fact, right? So if that's in dispute, why couldn't a jury say, Judge, this is the income that we find. Now you calculate the support. Because that's a question of fact.
Well, it's codified though. There's certain types of cases that a jury cannot decide. And that's per statute. And so, like one of them is possession and access, which I think is kind of odd, right? It's kind of funny because you can have a big blown, a 5-day jury trial on conservatorship, right? Like who the kid lives with, but ultimately the judge is going to decide visitation. And so why couldn't you let a jury decide that, right? It's just per the code. That's all we can say. So
Yeah.
Common law and, all of this stuff. It's a great argument. It's just not going to get you anywhere.
Yeah, and that's not even an argument really the jury can hear. So they can't hear an argument as to whether a jury should be able to hear an argument.
Very good, Mr. Floyd.
So yeah, it just doesn't happen. Can't do it. Can child support and custody be filed without filing a divorce? You should know this one. So spouse has left us alone and is not ready to pay for any of the expenses, including child support. Want to demand help with child expenses. Am I eligible to ask for it without filing separation or divorce?
I never understand this logic. I guess I kind of do, but I have that happen quite a bit where we have clients who say, I don't want to file for divorce because I'm not ready to divorce him, but he's not helping me with the kids or she's not helping with the kids. So I need to file for custody. I guess, but like, if they bounce, like, why not just file for divorce? I don't know. But so the short answer is yes, you can do it. Okay. So, and we've done it several times. We pursue a SAPSR without filing a petition for divorce. A SAPSR is a suit affecting parent-child relationship. And in that context, the court is going to appoint you guys as conservators, either joint managing or sole managing. They're going to grant visitation. They're going to order child support. They're going to order medical support. And then they may order standard injunctions or even special injunctions prohibiting certain actions from taking place. So you can most certainly do that. However, the inverse is not true. So if you file a divorce and you guys have children, that does have to be consolidated or heard at the same time as the divorce proceeding. So if in fact, let's say, I don't know, this case, let's just say it's dad who took off, mom just wants the child custody, and then dad goes and files for a divorce. After she files for child custody, then mom's child custody case would be bumped into the divorce case, and the judge would hear everything at the same time. I would probably, if I were doing this consultation, would probably encourage this person to go ahead and proceed with a divorce so that you could potentially, depending on expenses, qualify for temporary spousal maintenance, and try to get a little bit more help there with expenses. But yeah, you can do it.
You could do it for strategic reasons, right? Forum shopping. If the SAPSR and the divorce would be in two different courts and the SAPSR court would be more favorable to you, file there for strategic reasons to get what you want on the SAPSR, and then file for divorce to consolidate, rendering them unable to modify the SAPSR. So you have a SAPSR, and this court's favorable for whatever reason, whether it be drug related, not co-parenting, whatever. Some court may be more favorable to you in a SAPSR than the court that would have jurisdiction of the divorce.
So yes, I'm picking up what you're laying down for strategic purposes. Yes, you could do that. So long as that's where the kiddo's residing in this other county, then you could do that. But all dad would have to do is just file divorce in whatever county.
For sure, if his attorney's smart enough.
I mean, that's not that brilliant, Mr. Floyd.
Well, I mean, it may be brilliant because dad may not want a divorce or dad may not hire an attorney. Whatever the case may be, there may be strategic reasons for filing the SAPSR, not with the divorce.
Okay.
I see it a lot.
I like it.
I see it a lot when there's an informal marriage. The AG will file if the child's on Medicaid, and they'll do the SAPSR, and then they come to us for a divorce because they were informally married and not formally married.
Yeah. No, and I've just had people say, I just don't want to get a divorce. I'm not ready for divorce. And I mean, I guess I understand it, but it's just, and I always try to explain to people that just because you file for divorce, when you file, that doesn't mean that boom, you're divorced, right? So in the state of Texas, it takes at least a minimum of 60 days to get a divorce, unless there's some sort of family violence or something that took place, then you can request that it be expedited and get divorced sooner. But in the state of Texas, it takes a minimum of 60 days. And so if you find yourself in this position of, listen, I really want to, separate, and I really need to make sure that my property is protected and my, kids are protected and bills are being paid, etc., you can always file, get temporary orders, and then see how things go while those temporary orders are in place, and then potentially reconcile and non-suit the entire case. And it's like it never happened before, right? It makes me incredibly nervous when there's community property, there's divorce, there's, just credit cards, insurance, etc., and we're just kind of leaving that open and nobody's addressing that with restraining orders or injunctions or anything like that, and solely just worried about the kids. Because you could have people liquidating assets, people running up credit cards, all sorts of craziness going on that could have been prevented with a TRO. Okay, next question. Can a family attorney judge deny a jury trial after I had already paid and requested it early on? The judge granted a withdrawal just days before our MSJ hearing. I was on my own. Subsequently, on a phone, the judge informed me there would be no jury trial. I was flabbergasted. What a great word, flabbergasted. I needed to show my evidence and show the lies of my husband's testimony and deposition. I had told the judge my husband wanted to leave me destitute after over 20 years of marriage. I was totally dependent on him. The judge ordered our divorce final, and I was left destitute. No car, no furniture, no home, no retirement, no money. The judge rendered the decision no community property. How can that be?
I'm guessing summary judgment was maybe on the marriage, right? Maybe this was an informal marriage, since he said no community property. That doesn't seem likely after they've been together 20 years. If they were in fact legally married, then I don't know how it would be possible to have no community property. So my guess is the summary judgment was on whether or not there was in fact a marriage, and the judge found that there was not a marriage and there was no issue. Well, but he rendered the divorce final. So if there was community property and the jury trial was requested and paid for on time, she would have the right to have that issue tried before the judge.
Well, it depends on when she filed it. So if it's filed within 30 days of the final trial, that's potentially deemed to be untimely. And the court, it's discretionary at that point if the court's going to allow it or not. And so maybe she filed the jury trial request late.
Yeah, that would be the not on time.
Correct. Untimely would be another word for that.
Or you could have just said what I said. If she had filed it on time, then it doesn't make sense.
Untimely sounds better. I think that either she didn't file the request for jury trial properly, maybe she didn't pay the fee, maybe she filed it not on time.
Untimely.
Maybe there was a premarital agreement, maybe everything that he purchased was from separate property funds, maybe it was the fact that she didn't have an attorney.
For 20 years, there's no way there was no community property.
Maybe he inherited millions of dollars and everything that he purchased was just from his inheritance. You don't know. It could happen. It could happen.
No way.
Maybe she just didn't have an attorney, and because she didn't have an attorney, she got screwed. And I cannot tell you the number of times that we have had people come in and hire us either because they didn't have an attorney or because they had an attorney that was not so great, and they just have their asses handed to them.
Well, so it's not about having her ass handed to her. It's about the judge violating her right to a jury trial when she requests one. And so I agree with you. We're not hearing the whole story, right? Either she didn't do something correct, there wasn't an issue that could be put before the jury after the summary judgment hearing, but I don't foresee a judge just taking a properly filed and request for a jury trial and saying, nah, I don't feel like giving you that right today.
No, I don't see that either. And maybe they did a, no evidence summary judgment. And what's the other one? What is it? Traditional summary judgment. And maybe her previous attorney just didn't respond. And if they didn't respond on the issue of whether or not a marriage existed.
But it rendered our divorce final. Maybe she just didn't understand. Maybe he just closed the case. Yeah, I think there was an issue with regard to the marriage.
So I'll say that summary judgments freaking suck. I hate them. Absolutely hate them. We filed them against other people. They filed them against us. And basically what that is it is a motion that is filed to basically say, listen, you can't meet a core element of your claim, i.e. you can't prove that a marriage actually exists. And so we have to go in and we have to show, yes, we can. Here's how we're going to prove all of this stuff, right? Through depositions, through evidence, through testimony, etc. And so the timelines on those things are pretty goofy. And if you're not paying attention to them, and if you miss them, it could potentially have really bad consequences for your client. And if you're the client yourself and you're representing yourself, then those deadlines are pretty damn important. The other thing is when you're drafting this stuff, the rules of evidence are still applicable. And so that is also where a lot of people get kind of screwy on it, because they proffer all this evidence without remembering the rules of evidence. And then the other side gets to file objections to the stuff that you filed. And if their objections are sustained, then your evidence gets kicked out of your motion for, or your response to motion for summary judgment. And then the judge is only left with certain admissible evidence. And if it's not clear enough to meet your evidence, you're screwed. And so I suspect that that's probably what happened here. They screwed the MSJ, and
The attorney bounced before the hearing.
yeah, no point at all.
Certainly rude.
Yeah, very rude. So that sucks. And that's why I tell people all the time, it is so important that you hire a good attorney, especially if you're in this situation here, because you can be left, in her words, destitute, all because somebody screwed something up.
And then you would be flabbergasted.
That is quite flabbergasting.
Let's go with it. Can I get arrested while applying for a marriage license in Texas if I have a warrant out for my arrest in Texas? I think the question, I'll keep reading. I might have a warrant out for my arrest for some unpaid traffic tickets. Me and my fiance are looking to get married soon.
What do you think?
I think if you're in Texas and you have a warrant in Texas, you can get arrested. I don't care where you are.
Oh, yeah. But they're not going to check that when they go and apply for a marriage license, are they?
No, they won't run you for warrants, but I do think that if you have the money to get married, pay the damn tickets.
True that.
It's a lot cheaper to pay the tickets than to pay for a wedding.
Yeah, for sure. Yeah, they're not going to run that. You'll just go in and fill out your application, and that's the extent of it. But yeah, that's not very right. So pay the tickets.
Yeah, just cut the DJ back a couple hours, pay your tickets, be good to go. Can a Texas resident get California rate child support if the children have lived in Texas for over 5 years? My ex-wife took my children out of California in 2017 and moved to Texas. I agreed to pay her $500 in support. I ended up losing my job and was able to pay her child support. She then filed for child support, but somehow California did the ruling. It is my understanding that California does not have jurisdiction over the kids who live in Texas. Yeah, because I had this case. I mean, the party didn't live in. No, it goes where the non-custodial parent lives.
Right.
He lives in California. Yeah, so that's where it would go.
So, because I had a case where the case was originally, let's just say it was out of California, it was some other state, but the case was originally out of California, and then mom and kids moved to Texas, but dad had never lived in Texas, didn't, submit to jurisdiction in Texas, nothing like that. And so in that particular case, we did our research and we ended up non-suiting mom's motion to modify child support because she didn't have jurisdiction in Texas to modify that California order, because dad had never lived here. But we've had other cases where both parties lived in another state, and then they both moved to Texas, and even though the previous order was in California, then we were able to register and modify. So I guess that's it. It's where dad lived. But what if dad had moved from California to like New York?
Well, then you could do it in California or New York, I think, because it's a personal jurisdiction issue, right? So at that point, dad had submitted to jurisdiction in California. If he moves to New York could have jurisdiction over him. But if he doesn't meet any of the criteria for personal jurisdiction in Texas, then Texas can't order him to do anything.
Yeah, but what would be the controlling law? New York or California? I feel like it stays with California. I feel like I read that or studied that you have to use the court of continuing exclusive jurisdiction to be able to modify those numbers. She can then file for child support, but somehow California did the ruling. Yeah, so no, that's right. California did do the ruling and California should have done the ruling. And what if he had submitted to jurisdiction in Texas for the modification? What if he had filed a motion to modify in Texas,
Then Texas would do the ruling.
right?
Yeah.
Yeah, that's what I think we would have done. It's filed here so that we could get a lower rate, because I think California support's higher than Texas support. So,
I don't know. I haven't calculated support in California.
I mean, it's California, like everything's more expensive in California, no?
I'm not a California hater. I love all the states equally.
Yeah, so I think that that may have been the play, or may still be the play. File in Texas, request a modification, and then see if you can get it reduced. Easy breezy. Okay, next question. Can my daughter's boyfriend take my grandchild just because he signed the birth certificate and I know he's not the biological father? My daughter is incarcerated and her boyfriend, who signed the birth certificate, knowing he is not the biological father, is trying to take my infant grandson.
Where's Julie when we need her?
Right, right.
So the answer is yes, he can take the grandchild. Man, there's a lot to this. There's a lot to this question. So let's presume that the child is not 4 years old. The reason we're going to do that is because there is a statute of limitations after 4, but there's an exception to that 4-year statute of limitations. This is how deep you want to go. This is going to get crazy.
Yeah.
All right. So the rule is that he is what we call an acknowledged father. So in Texas, there can be 3 types of fathers: acknowledged, adjudicated, and presumed. So he's an acknowledged father, could potentially be a presumed father if he had resided with the child. Okay, so if he lived with the child for 2 years and represented the child as represented others that the child was his or whatever, then he could be a presumed father. Daughter needs to hire an attorney and they need to file an adjudication of parentage. And biological father needs to join in on that suit. They need to get a genetic test done. I don't guess we need bio dad, right? Just have daughter file an adjudication of parentage, request genetic testing. Genetic testing shows boyfriend's not dad. And potentially could get an order adjudicating him not to be the father. I think it would be hard to argue estoppel under this per the CDC's infancy guidelines.
Yeah, we can save that discussion for later on.
Oh, you don't want to get into all those?
So yeah, yeah, what you said first, the decision to adjudicate parentage, that's the way to go, Floyd.
Yeah, okay, perfect.
Yeah, request genetic testing. What about grandma? Can grandma do anything?
I don't know. That depends
On
whether she was living with the child or the mother, and whether the child was living with her, or whether she was living with the parents and the child, whether there's a danger to the child. So if grandmother can prove that neither one of the parents, in this case, daughter and her boyfriend, should be named a managing conservator because it would cause the child to suffer serious and irreparable harm, then she could file to be named managing conservator. If she has had care, custody, and control of the grandchild for 6 months, she could file for managing conservator. Anything else? Huh?
No, I think that's it. I think those are the 2 grounds.
So I think you need to maybe talk to an attorney that's handled these types of cases before. I know some good ones if you're up in the Dallas area or the West Texas area that have actually, oddly enough, quite a bit of experience with these kinds of cases.
By you mean we, right? We, us. We're a team.
No, I think I deter them. I think you are the one that attracts them.
Yeah, so bottom line is anytime, and unfortunately, this crap happens way more than what it should, where people are signing birth certificates. Maybe they're signing it because they don't know that they're not the father. Sometimes they sign it knowing that they're not the father. Which, there's all sorts of fraud issues and things like that when you do those things. But bottom line is that there is a very short window that you have to be able to contest this. And there's exceptions to that window, right? And so I will tell you that we have spent countless numbers of hours researching these types of cases, because there are so many different nuances, and it's going to depend on, once again, your particular situation, your facts, to determine whether or not anybody can do anything to help you. So at this point, I say, yeah, bio dad or acknowledged dad gets to take kiddo unless you get a court order stating otherwise. So hire a lawyer. That's a good hire a lawyer question.
It's a great hire a lawyer question.
Yeah.
All right. My question. Were you going to read the question?
Oh yeah, I was going to read the question.
No,
Yeah.
It's my turn to read the question.
Oh, okay. Sorry. Go ahead.
We're trying to steal the show.
Okay.
Do they have to go to their dad's house? Ages are 13 and 16, and we have 50-50 custody in Texas. Based on my own experience while married and dealing with him now, I worry for my children's mental well-being and believe there is a form of mental and emotional abuse occurring at his home.
These are my least favorite types of cases. I guess we have some that I hate more than these, but these are always super tough. Because I do believe that these types of things happen, right? But I tell my clients all the time that it is one thing for you to tell me that something is happening, and it's quite another for me to be able to prove that it's actually happening. And mental and emotional abuse is extremely difficult to prove. Unless you have a 13 and 16-year-old go into court and talk to the judge and tell the judge, this is the kind of stuff that is happening at this other house, and this is why I don't want to go over there, right? I've had some cases where the kiddos record like things that are going on in the other house, and then they give those recordings to the other parent, the parent that they want to live with. I have mixed emotions on that. On the one hand, I understand the kiddo trying to be protective of themselves and document what's happening. On the other, I think depending on the judge, that could get you in really hot water. And it has this perception of, are we now involving these kiddos in litigation? Or is mom or dad making them do these recordings? And so that is, but how else do you prove it, right? How else do you prove emotional, mental abuse? Typically that's words, right? So I guess in theory, kids could do that, but that would be a judgment call for the attorney and knowing who the judge is. And if it's going to be something that's going to be highly offensive to them, I typically err on the side of not using any of those recordings, because I just don't like it. I don't like it, and I think most judges don't like it. The best bet, I think, in cases like this is to get these kiddos in counseling and have them go and express to the counselor, like, hey, this is what I'm feeling. This is why I'm feeling this way. This is what my mom says, my dad says. And then that counselor can then come in and testify as an expert as to their mental health and their emotional health and the impact that they are, that these words are having on them. I would say, what else, Floyd? Counseling, a motion to confer with kiddos this age. You can ask that the judge talk to them in chambers and have the kids express to them what they want and why they want it, why they don't want to see mom or dad.
That's it. That's all you got.
That's all you got.
Maybe there's some text messages, but it's difficult to try to get those in. There are ways, right? If there's text messages somewhere, maybe from mom or dad, in this case, from dad that's being abusive,
Right.
or outcries from the children via text to mom or something like that. Maybe there's a way to get those in, but
Yeah, so I mean, the short answer is do they have to go? Yes, they have to go. They have to go until such time as you modify this court order. And I cannot tell you the number of times that I have had parents come to me and say, well, I don't want to let them go because of emotional abuse, or because I know that the other parent drinks a lot and I'm worried that they're going to get in a car accident, or because the new girlfriend is over at the house and I don't like her. Don't care. I don't care. The judge isn't going to care. Nobody's going to care until such time as you get a temporary restraining order saying that they don't have to go. They should go. And if they don't go, then you could potentially be at risk for a contempt action. And so you need to get proof. You got to get proof of this. And I think the best bet is a counselor and also visiting with the kiddos.
or with 50-50 possession, maybe teachers, right, can testify to how they're behaving at school, or whether their homework's getting done, or their mental and emotional health while they're at school.
Yeah, they're tired, or if they're just upset when they come over to school. Coaches with a 13 and 16-year-old, I've used coaches before where they say, like, listen, they were doing great when dad had primary. Now that we're doing 50-50, her home mental health, you like that?
That was the one I asked for. Yeah, good.
But now that we did a 50-50, it's gone to hell. So yeah, I mean, with this one again, and these are the types of cases that I will say we spend a lot of time strategizing on, a lot of information gathering, a lot of talking to different witnesses, because without it, we don't have a case. Boom. Alrighty. So we say this at the beginning, middle, and end of our event, that please don't take this as legal advice. We, proffering this, I guess, not evidence. We're not proffering evidence. We're having these discussions on Facebook Live just to give you guys some ideas about things that could happen, some things that you should and should not be doing. But really what you should be doing is hiring your own attorney. You should be talking to that attorney about your case and telling them all the facts, all the ins and outs of your particular case, and following their advice. Because at the end of the day, they're the ones who know the judge. They're typically the ones who know the law, and they're going to guide you down the right path. So with that being said, I hope you have a wonderful weekend.